Tell here tonight. It's great. It's 7 o'clock, October 11th, and I'll bring the Board of Selectmen's special meeting to order, starting with a roll call from my right.
Paul Sanderson.
Chester Duraki.
Ron Morgan.
Jim Ralston.
Chip Huzzy. And we have a quorum, and the meeting is being recorded.
And it is on. Yes.
And the special meeting has been called relative to the library expansion project. I want to make something very, very clear here. Neither the Board of Selectmen nor the Planning Board are, as some may think, anti-library. The town voted to expand the library, and as elected officials, it's our job to endeavor to accomplish that task, whether or not we individually agree with the vote. However, as your elected officials, we are also tasked to see to it that the project conforms to the laws of the state of New Hampshire, ordinances set forth by this town where applicable, and is prescribed in a safe manner. We are holding the library's trustees' feet to the fire as we would do with any project. This is our job. For example, our town desperately is in need of a new fire station. That issue was brought up at the last town meeting. A committee has been formed and is currently in the process of formulating a plan and design for a warrant article for the next town meeting. We will require that that project will meet the same strict requirements as we are putting on the library project. It is incumbent on both the Planning Board and the Board of Selectmen to assure our residents that projects such as these are done safely and correctly. That being said, this meeting is convened because several of our selectmen feel strongly that there may be some serious violations confronting the library project and would like to consult the Attorney General's office to make sure that this project is not out of compliance with any statutes before continuing any further. Because if they find halfway through this project that there were any violations, they may put a cease and desist order in place. This is, in my opinion, only common sense. I called a special meeting because I realize that time is of the essence regarding finance and construction issues. Now, I want to make it clear that this is a meeting, not a hearing. We have a lot to discuss and resolve. I do not want to be sitting here tomorrow morning for breakfast. So for the sake of expediency, and unless the majority of the board objects, I am restricting comments from the public. Now, the board is of varied opinions on this issue, so I'll start by asking Mr. Sanderson to expound on the issues that may be contrary to the rules and regulations that the library committee should follow, and then we'll ask for discussion among the board members. So, Mr. Sanderson.
Thank you. For the benefit of everyone, I'd like to go back just a little bit and go through how these questions have come to light. On Monday, October the 1st, Karen sent out to not only Craig McLaughlin, but also members of the board, an email indicating the email below is regarding the window wells, but also shows the control of the real estate. The septic issue is also not an easement, but notes that it was an agreement between the parties, and my signature block shows a continuation of that agreement. I've copied the Board of Selectmen on this so they're aware that this issue may come up about the parish house septic. I'm in the process of finding the correspondence about the septic replacement from 2014 at this time. And the copy of the email that she gave to us was a discussion that she had at that time with a person whose name is Terry Knowles. Terry Knowles is the Assistant Director of the Director of Charitable Trusts within the Attorney General's office. Okay. And Karen's report to the Board of Selectmen back on February the 2nd, 2016 was as a result of this email from Terry Knowles. Hi Karen, I just left a voicemail on your phone. I received a complaint from a Greenland citizen alleging the Board of Selectmen has made the decision to grant an easement of library land to the Greenland Community Church. The library land was given to and accepted by the town of Greenland with the following restriction. Said grantee shall use the granted premises for no purpose other than that of the location thereon of a public library. If the selectmen have voted to use a portion of the property for a purpose which is not consistent with the intent of the donor, it's important that we discuss the issue as soon as possible. Karen did have a discussion with Terry Knowles at that time, and her report to the board reads, I just spoke with Ms. Knowles and she's confirmed to me that the Board of Selectmen have the control over the library real estate as trustees of the original trust when the property was given to the town of Greenland for use as a public library. The statute that I had referenced, which is the library statute relating to the ability of the trustees to control library property, that's in RSA 202A, does not give the library trustees the right of ownership, but rather management. She also said the Board of Selectmen could not grant an easement to the church for the window wells because it would be transferring property given to the town for a library. She did agree that a revocable license from the selectmen to the church would be the appropriate method to handle the use of the 20 inches, and at that time it had to do with window wells that were along the side of the building, and that would not violate the terms of the deed. The window wells could be removed at whatever time the selectmen determined they need to be. I've copied this to both Attorney Laughlin and Attorney Lowry, and I believe she was probably working with the church at that time. Okay.
And they worked together to design the agreement that the Board of Selectmen signed.
Okay. For their review. It is the church's responsibility to have the revocable license prepared for the board's signature. This will be the first agenda item on Monday. That came to us on Monday, October 1st. The planning board session was on October the 4th. The presentation was made. On October the 5th, I wrote an email, which anyone's entitled to a copy of, saying that I thought our first task, based upon that session on October 4th, was to document all of the existing conditions on the site for the Office of the Attorney General so we can have them determine what, if any, violations are in place, assign corrective actions, and come back into compliance. That is, we have to come back to a compliant condition before we start to make more changes. And then I said, actions. Town staff must put together documentation from the installation of the septic system and installation of the window wells. The library needs to give us a plan set for existing conditions at the site. Once assembled, the selectmen will be consulting the Office of the Attorney General. Library trustees or staff get a copy of this material, but they're not part of the discussion about compliance with the Attorney General's office. Why? Because we already have a ruling in place that only the selectmen make decisions about this real estate. Our board needs to make a decision about who will lead or participate in these discussions and whether or not any legal counsel will be involved in the process, and if so, who that will be. Number three, once we know what compliance means and what actions may be required by the regulator, we as a board will have to decide about further required actions at that time. That means that in the meantime, neither the library trustees nor its architect negotiate with the church leaders or the other abutter and attempt to make any binding promises about this real estate. I was very disturbed last night to hear the architect say this is just lawyer stuff. It's clear he doesn't understand what has happened here, its implications for the future, or the duties that we all have moving forward. I don't think for a moment he will slow down in any of his discussions with others, and what he says or does may have a negative implication for everyone. For that reason, we need to communicate with the architectural firm and library trustees in writing to tell them to cease and desist these unauthorized efforts. We also must be in communication with Underwood, the engineers, and DES, because we have no idea what's been filed with them, what representations have been made, and who signed any documents regarding a subsurface application. Remember, applicants are responsible for any inaccuracies and can be subject to monetary fines for making inaccurate, misleading, or false statements. Nobody wants or needs that to happen here, as it only compounds the problems. We may have to notify DES of these events if the filed paperwork is inaccurate. I believe we must also advise bond counsel in writing of what is happening here and determine our status with them. Representations may have been made that are no longer accurate, and we need full disclosure with them and the bank before we proceed along that process. And then finally, if anyone believes we need a meeting before the regular one on October 15th on these matters, schedule it up and let's get going, which is exactly what we're doing tonight. Since I wrote that email on October the 5th, I have a little more information in that I took a look at the online subsurface one-stop paperwork from DES, and what I find in there was an application with all of the details that was signed by Marcia McLaughlin, and then I also have, if I can get to here, the latest document that has been issued by DES that is in their online one-stop system. And that's a letter to Underwood Engineers dated September 11th, 2018. And it deals with this particular work number. DES has reviewed the above referenced application and has determined additional information is needed to clarify and complete it, or design issues exist that must be addressed. Number 1, provide a deeded easement for the benefit of Lot 17 to locate, maintain, and replace the septic system on Lot 18. Provide a deeded lot loading easement for both Lot 17 and 18. And then there are various other technical aspects about the design of the septic system. Finally saying, upon changes to the plan, additional review will be required. This is also a public document that anyone can get online at the state's website. The reason I'm so concerned about this is because of RSA 7. Now, I'm going to be the first one to admit to you that being a lawyer with municipal experience brings with it a whole lot of challenges. The fact that I probably know more than I should. There are many days I wish I didn't. If you take a look at RSA 7 and you look at the powers of the Director of Charitable Trusts, okay, it applies to all trustees holding property for charitable purposes. What in fact is a charitable trust? That is defined in the statute. Okay? And a charitable trust is defined any fiduciary relationship with respect to property arising under the law of the state or of another jurisdiction as a result of a manifestation of intention to create it, and subjecting the person by whom the property is held to fiduciary duties to deal with property within this state for any charitable, nonprofit, educational, or community purpose. Fiduciary duty simply means the highest possible standards that anyone can be held to, well beyond the ordinary prudent person. We have special duties. If in fact they have concerns at that office, they have extraordinary powers. Okay? They can require any of us to participate in an investigation, to provide all necessary documentation. If they give you notice, you will be going to Concord to provide all of this type of information. They even have the power to require a person not to exercise their Fifth Amendment rights against incrimination and require them to provide information. The only thing that they will give you is that even if you decide that you want to exercise your Fifth Amendment privilege against self-incrimination, they simply will not prosecute you. If they find that you have violated any of this, they have the ability to have a court award civil penalties up to $10,000 for each violation. And for these particular violations, people are personally liable. They can't be indemnified. So the normal rule that we have here, that if we're acting in accordance with what we perceive our duties to be, that we're protected and indemnified, it doesn't apply to a charitable trust. Okay. So that's why I have said here, we have to collect our information, self-report, disclose, and determine, and have them determine for us where we are. Does that existing septic system cause this to be a violation? It is a septic system that runs from the parish house onto the library. And what benefit does the library receive of that? Right now, nothing. Is that a violation? I don't know. But I sure don't want to go any further until they tell us. If there was concern in 2016 that a window well, in fact, was a violation, I'm most concerned that a septic system that puts over 300 gallons of sewage a day over into library property is in fact a violation. I don't want to make any more changes until we've self-reported and have them to tell us, are we in trouble or not in trouble? I don't know, but I sure don't want to proceed till I find out. And that's the basis of why I made these communications to the board and why I made the suggestions I did. And so based upon that, please, let's discuss.
The only information I can have at this point in the request for me to pull up whatever documentation I could find was that in 1956 is when the agreement between the library and, well, the parish house and, I can't even find whether it was with the library or through the Board of Selectmen, I can't find who this verbal agreement was done. But it was July of 1956 when the Methodist Church sold the parish house to the Congregational Church. And there's pictures online of them getting appropriate sanitary facilities to the building. So that's when the septic went in to service the parish house, and its original septic was in the back of the library property.
Okay.
That's all we can find is that we know in July of 56 they got their toilets.
And then in 2014, other changes were made.
Right, the system had failed. They went to DES for an emergency replacement of their septic system. At the time they worked with, I believe, I'm not sure whether it was the planning board, but I know it was at least the library director and the building inspector at the time, to move the septic to the center, to its current location, sizing it adequately for future library expansion.
Okay. And do we have any documentation between the church and the town? Were there any agreements or easements or other?
There were no easements. I signed the plan that went to DES on DES's request. They did a box that, and I have a copy of it, that said that this is a continuation of a long-standing verbal agreement with no documentation. And approving this emergency moving of the septic continues that same agreement.
Okay. And I take it no discussion with the AG's office at that time?
No. That happened shortly, a few months before the window well issue.
Okay. When the window well issue came up, was there any thought saying, gee, what did we just do? Is this something we need to report?
The window well issue, originally the board met with the church and said, okay, we'll do an easement between, and the resident whom I am aware of called Terry Knowles Direct to say they can't do an easement. And so that's when that came back to us. The two attorneys worked together and with Terry and said, you can call it a license, and then we have no problem with it.
Okay.
You just can't, an easement is a permanent right, and you couldn't give them a permanent right to that property.
Okay. And so knowing that, we now know that we have at least a current problem in that the plan that's been proposed by our current trustees would require some sort of an easement here in order for DES to reach an approval on their proposed new septic system.
Not correct.
I'm just reading from their request for more information letter.
Right, their new septic is totally on their own property.
I understand, but it's still collecting sewage from the parish house,
Okay.
right?
I don't know. I don't know if the two units were then going to be tied in. Currently, they're both on separate systems.
But to the best of my knowledge, the one new septic system that's being proposed is designed to handle the effluent of both the new proposed library building and the existing parish house building.
Okay.
Okay. So therefore, something would have to be created in an agreement between the church and the town, library, whoever's in authority in order to deal with that.
Right.
So it would be my view that we have to disclose all of this to the Attorney General's office and get instructions.
Can the system be shared
Right.
between?
That's my view. And please, any other member of the board who may disagree?
Well, I would just like to say something that can be shared as it presently stands or with the expansion. In other words, the parish house, as I believe it, has a conference room that can hold, what, 100 people?
Well, just from having been in the building, when you walk in, there's an anteroom, and then there's a very large room that could hold probably more than 100 people. Behind that, there's a commercial kitchen, and there's a set of stairs that goes down to various rooms they have in the basement, a set of stairs that goes up to offices that are used by the pastor and the others in the church for church purposes.
Okay, and the proposed expansion of the library, their conference room could hold 100 people?
I think that was the general proposal.
66.
6 people, okay, all right. Because, I mean, I think that's important if you're talking about, the
Yes.
septic system.
Yeah.
Okay, all right. Okay,
Okay. But my view is that without receiving permission from the Attorney General's office, the Board of Selectmen could not enter into any agreement with the church with regard to accepting effluent from them, because that's not directly a library purpose.
okay.
That's my view.
All right, so that's the question, this is one of the questions to Terry, or to whoever, she's retired though, right?
But working part-time.
Working part-time, okay. Can the septic system on library property accept effluent from the parish house?
Yes.
Okay.
Okay, now,
And also.
And what kind of agreement is necessary?
Yeah, and right now, considering that the system exists, is the current system a violation or not? I don't
Okay.
know.
Excuse me, we have guidance.
excuse me, please.
All right.
And just further members of the board to reiterate, the reason I'm saying this is that we can't make this decision for ourselves. Okay, this is a charitable trust. And so therefore, we must talk to our regulator.
So if we,
Excuse me, Craig, I had a conversation with you before the meeting, and you agreed to it.
Yes.
This is no comments from the public, and I'm going to enforce that. Please, I'm going to ask you again, one more time. All right?
All right.
Do we
One
understand
question.
each other? Do we understand each other? Thank
Fine.
you. You and I had an agreement. All right. Are there any comments from the board?
My understanding is the original agreement is recorded with DES as being verbal, we're not sure by who, correct? Town government?
Right, 1956.
I kind of get the feeling the town minutes aren't as good as they are now.
Well, actually, in 1956, there was no DES. But there must have been some discussions in 2014, and I don't know what they were, because I wasn't here. And DES at that time did something and gave a permission to allow that system to exist.
So right now, I know that the chair will be able to have a good argument against that one. And it's the new one we're having the issue with, correct?
For me, I'm not trying to take a position other than I need instructions. I don't know. You know, to me, there is an argument, and it's a really good one, that the effluent that's currently being received from the parish house has nothing to do with the library purpose. Okay? And so that leads me to think, I ask my regulator, is this a problem? It's not my decision. Okay? The Director of Charitable Trusts is the one who can provide us guidance as to whether, as fiduciaries, that is a violation or not.
well, as I understand what's been said, didn't the regulator give approval back in this past agreement was made?
In 56, I have no idea.
No, and in 2014, DES gave the approval based on the agreement, but it did not go to charitable trust. We didn't know at the time that it should have gone to.
Here's the technical question. I'm assuming charitable trust existed back then.
Yes.
Okay,
And
because I know DES did not.
Right. The Director of Charitable Trusts very definitely existed back then, but we can't find any documentation of discussion, so we don't know. I'm not accusing anyone of anything, we're saying we just don't know.
That's it. We don't know enough. We can't answer these questions, so we're gonna
Right.
kick it up.
Right, and I went through
And
the
then we can
archives
move on.
of Portsmouth
Either way.
Herald to see if there was anything about it there, and all the information basically was revolving around improvements to the parish house, to bringing them in, plumbing and all that. But it was simultaneous with the sale of the building from the Methodist Church to the Congregational Church.
They may have a file there that's more extensive, I don't know.
Right.
I don't know.
Okay, it seems like there's a lot of I don't know questions that need to be answered, and we know where to go to get the answers. I mean, that's obvious, so.
Right here.
We know where to go to get the answers. And again, this is a matter that's amongst the Board of Selectmen, not any other body. It's strictly with the Board of Selectmen. We have to find out because we're the ones that are in charge and responsible. I, for one, would like to get this resolved as quickly as possible. I want to move forward with this thing, but I want to make sure it's done correctly. So if issues like this are brought up, I want them resolved. So I think your point is well made. We should go to the Attorney General's office with these questions. Let's get answers to them. I also have waiting for answers from the Planning Board and from our building inspector too. And I've been very, very open with the library trustees and the library committee. I want answers to these questions. These are safety issues that to me need to be resolved.
Okay, I'm going to interrupt you, Vaughn.
Yeah.
You're talking about the zoning issues that the planning board brought up are not safety issues that can be enforced on the library.
Well, there are safety issues also that were brought up by the planning board.
They're part of the safety, New Hampshire life safety codes?
That are part of they know better than I do about that, but again, it's something that I need answers from.
Okay, because I don't want you to get confused between the two. One we can enforce, life safety we can enforce.
Yeah,
Zoning we can no way, shape or form enforce on.
understood, yeah.
And so we can request them real politely.
And I do want to move this thing forward as quickly as possible, I really do. I want to get it resolved, and I want to move it forward quickly as possible. The town did vote for this, and I am obligated to do what the town elected me to do, which I will do, but I need to make sure it's done safely. If the town votes to put a bridge over the Winnicott River, I'm for it. Even if I vote against it, I will sign the papers and all the rest of that stuff. But if that bridge isn't done safely, then I'm incumbent not to sign those papers. Because I'm looking out for you guys, whether you think I am or not. I really am. I put my thoughts aside. It's what the majority of the people have voted for is what I will go forward with, but I need to make sure it's done safely. This is a big project. It really is, so that's where I'm coming from.
Are there any other issues that need to be brought forth before the Attorney General's office regarding this project, though?
To the best of my knowledge, no, because they wouldn't be involved in the financing. That has to do with bond counsel and the full faith and credit of the town. That has nothing to do with the charitable trust. The usage that they're proposing there, obviously, library on library property, so I don't think there's a use problem. I think it's this problem, which is whether or not that effluent that exists there now and the receipt of effluent in the future would in fact violate the terms of a charitable trust. And that's a question that I do not know the answer to.
I may want to add, since we got to go to them, add one more question.
Sure.
In some free chance we win Mega Man's and put sewer in the town, can they cross that property with a sewer line?
That's a very good question. And I don't see any reason why we couldn't include that in our communication to them. Because after all, right now, there's water and gas that comes in close proximity. I don't know if it's exactly on the property other than the service that goes to the building. But who knows in the future? Utilities underground.
Well, that's why I was bringing it up. If I know it's almost like going to probate and it's like a beat your head against the wall type situation.
Right. And so the question is, can sewer lines go in the property of the library that will ultimately serve other properties?
Exactly. I won't be worrying about it, I don't think.
Yes,
Can we also say the time is of the essence on this?
absolutely, yeah.
Yeah. And the best way for us to get a prompt answer is to give them the documentation that we have from all of the things that have happened. For Karen to put together that documentation from 1956 and 2014 and 2016 would really help.
Okay. Any other comments, questions from the board? Is the board in agreement? with moving forward with this and getting these answers?
We gotta get it done.
We do.
This is getting pretty old quick.
Well, I'm in agreement.
Okay,
Are we all in agreement?
all right.
If there are other resources that I can use to get some of this information, may I?
Absolutely.
Thank you.
And what do you think you might need?
I would like to check with Mr. McLaughlin that he said he has some of the documentation.
Absolutely. yeah.
Fine.
Yeah.
Yes.
Thank you.
And as I mentioned to Mr. McLaughlin afterwards, we have a regular meeting on Monday. If he'd like to put himself on the agenda, I am more than happy to entertain his questions and thoughts.
On Monday, okay.
Hey,
Are
fact
you going to
check,
want to do that?
Absolutely.
Okay, because my agenda closed, but we're good. We can get you.
hey, fact
Because
check,
it's already
to find
Thursday.
out who was deacons of the church then and who was selectmen may be a good idea
Oh.
too. Because that may be why there's no
Why
written
did
record.
Paul Hughes already pass away?
I know, I won't dig him up.
Oh, he has that, all that.
He must
have
access to it, no?
Trying to think who was the
He would
church
know
man.
how to put his hand on which book it's in,
Oh, don't
and he
even
would
tell
have
me.
the, he
You
would
ask
have
a
the,
question, he answer it.
he would have the article, he could tell me
3
who, what,
pages
and when. He was golden.
Being a member of the, voting member of the fire department committee, can you bring that up?
Sure.
All right, then I guess this issue will be closed, and Karen will take it from here.
Yeah, and we'll put Craig on the agenda for Monday.
Excellent.
Thank you.
That's okay. Yeah, I can tell you the selectmen were, because they got the records at home.
We got one other issue here. All
I
right,
looked through the town reports, that didn't help.
Okay. Well,
okay,
if that issue is resolved until Monday, then I would tell you, last night, the Fire Department Building Committee had a meeting, and we are proceeding on that. We're getting information that's going to go out for RFPs as of tomorrow. And in our meeting, we determined that when the responses to those RFPs come back, we may very well need to have the professional services of the town engineer to help us to understand what type of responses come. So we were to come before the Board of Selectmen and ask that we have the ability to refer this matter to our town engineer for review and assistance as part of the selection process. So therefore, on behalf of the Fire Department Building Committee, I would like to make a motion to authorize the Fire Department Building Committee to utilize the town engineer, Altus Engineering, to review and assist as part of the selection process for a construction management firm for the proposed fire department building.
I have a motion, do I have a second? I'll second the motion.
Okay, any discussion?
I have a problem.
Sure.
Altus is the planning board. And the last time we didn't have a review, we ended up with a funny circle out here with pavers in it. The town engineer, my understanding, is Underwood,
Correct.
and I'd rather have a second set of eyes look at it to make sure there wasn't a mistake in it.
Well, and absolutely, before any contract is awarded, there can be that. So it's your choice. Do you want to have Underwood help us with the review and selection, and then have Altus do any final design review, or do you want to do it the other way around?
Because you said town engineer, Altus engineer.
We were thinking Altus, but
Right, so
I-
planning board engineer, Altus engineering.
yeah, and again, I think on behalf of the committee, we have no objection as to which of the engineers that provide services to the town help us. We just need an engineer services.
Okay.
So if it's the will of the board that we have the initial services of Underwood to review the documents and then Altus do a final review, or the other way around, makes no difference to us, really.
I would recommend Altus because they've already reviewed the plans.
Okay,
And to date, they've already been working on it, so it would make it, oh, no, they didn't. That was a different project. Never mind.
No one has
I've
looked.
got too many projects going right now.
That is
I'm meeting
correct.
with Underwood tomorrow about Breakfast Hill Road,
Yet there is
Okay.
no engineering firm that has taken a look at the
RFP.
RFP documents.
Okay.
so would you like to alter that motion?
Pick an engineer.
Well, first of all,
What would be cheaper?
What?
What would be cheaper
Well, first of all,
and safe?
I'm looking at the fact that, seriously, out here we had a $50,000 boo-boo because we didn't spend $1,200 to have it reviewed.
No.
You haven't
We had it
reviewed.
reviewed, the board picked it,
Right,
and then didn't like it.
yeah, exactly.
It was
just
reviewed.
didn't- It looked great on paper, but.
Yeah, it wasn't reviewed unless you guys left it out of the
But that's all
minutes.
right, but that being said.
But that's what I'm looking to do. I don't want that ever to happen again.
We'll actually rename it Sodini Circle.
Right.
That's fine. Whatever you wanna do. I'll make it easier. All of us can review it because the planning board's probably gonna review it too. How's that work for you guys?
That's fine, we just need services to help us review. Underwood first, Alta second, that's perfectly fine.
Okay, now the bad news. I have a real problem going forward with the bond till we settle the library's difficulties.
This is not it is in preparation for a potential bond.
Exactly. I just want to put the news out there early so everyone understands. We're all under pressure now to get things done.
Yes.
Okay,
I'm gonna have a major problem going forward if the library isn't situated, one way or the other.
I have to tell you, I wrote these emails as quickly as I could because I agree with you.
Because that is, we got the, for those that don't know, budget-wise, we got the library still hanging out there, fire department, and the school's putting together a bond. All legitimate targets.
not to mention roads.
And if you
No, we only
would like to
mentioned
go to
roads, that's too much
Bayside Road,
money.
we could go there too.
So, it just gets, when you start mentioning bonds, people get confused, so I want to start knocking stuff down and get it situated.
Okay, so do you want to change the motion to a different engineering company, or?
I will be happy to amend my motion so that this is referred initially to Underwood Engineering. The idea being that the fire department building committee can have the professional services of Underwood Engineering to review submissions for a construction manager RFP.
Okay, I have a motion. And I have a second. All right, all in favor?
Aye.
Motion passes.
Thank you.
Move to adjourn.
Hold on. Jim has,
Oh,
I'd like to request we go non-public for personnel matters.
oh, okay. I'll second that.
all right, I have a motion and a second. To go into personnel.
And then we just need a roll call to determine.
All we need is a roll call to determine whether or not.
Okay, Sanderson, aye.
Rocky, aye. Morgan, aye. Walter, aye.
Trip, aye.
Good evening.
Motion passes.
You guys have to excuse us for going non-public.
Thank you all for coming.
Take care. Thank you.
Mailing today was
Good
good.
job.
I know. Your efforts. Hello, how's your mom?